that one organ should not perform functions essentially belongs to other is false. British parliamentary system has a large impact on our parliamentary democracy, but the framers of our constitution were intelligent and thus the freedom of judiciary was taken from USA. In our constitution, judiciary has been made free from biased influence of executive and legislature. To maintain the supremacy of the constitution, the judiciary has been empowered with a strong teeth to act as a watchdog by declaring such act of either legislature or executive to be void or unconstitutional, which violates the fundamental principles of the Constitution. Any law which violates constitutional provisions can be invalidated by the Supreme Court or the High Court. The Supreme Court has a vital power of judicial review which cannot be taken away. In our democratic system, the interests of the people of India are paramount. It is inherent duty of all the three organs, judiciary, legislative and executive, to perform meaningful roles in making the life of the people better. Such meaningful acts could be performed only with healthy interrelationship between these organs. Effective, transparent and accountable governance requires that all our three organs functions collectively towards the constitutional goal of ensuring that each citizen enjoys the fundamental rights available to him. The Supreme Court and High Court have been empowered to protect these fundamental rights. Whenever there is a constant failure of good governance at the hands of other organs, then it is a function of the court to check, balance and correct any failure. The function of the judiciary is to protect the rights of the people by limiting the government arbitrariness and abuse of power. The supremacy of the Constitution is preserved and protected by the judiciary. In past, the Supreme Court has declared the constitutional amendments ultra-vires when it found that it was against the spirit of the Constitution. It has restricted the amending powers of the Parliament to the effect that Parliament, by exercising the amending powers, it cannot touch the basic structure of the Constitution. In Keshwanand Bharti case, the Supreme Court gave its historic judgment and held that Parliament cannot change the basic structure of the Constitution. The judgment was criticized by saying that judiciary has crossed its limit. In past, there remained a constant tension between judiciary and legislature on so many issues. Sometimes it seems that judiciary has exceeded its limit by interfering with the policy decisions of the executive. Mr. Somnath Chatterjee took exceptional note of it in his statement during Dr. Kailashnath Memorial Lecture. He said, I quote, "The contention that judiciary should take on itself onerous responsibility of the governance of the country in matters which the Constitution has imposed on either the executive or legislature has serious implications." Unquote. Presently, when the corruption has become a common phenomenon in all the spheres of life, these three organs are also not untouched to this evil. As far as the conduct of members of Parliament is concerned, some of them were found to have taken bribe for raising questions in Parliament. Even when there is a coalition government, either in the centre or in the state, the members are given bribe to form the government. It shows that moral values in general have diminished. The highly praised public servants have been found corrupt. In such prevailing corrupt circumstances, the responsibility of the courts has increased. But recently the Supreme Court has made a remark on the functioning of Allahabad High Court, which has shaken the faith of the people. As evident from the past, there is a constant tension between judiciary and legislature, either on the question of creamy layers in reservation, or corruption issues, or judicial scrutiny of the decisions of speakers of legislatures. The relationship between the legislature and judiciary has become tensed. To remove this tension, healthy relationship between these three organs is very much required. A close relationship between the judiciary and legislature, not in a manner of controlling each other, but of a mutually complementary relationship, is required, and except where the Constitution has vested power in a body, the principle that one organ should not perform functions essentially belongs to other is false. Thank you very much.
Krishna, to come up the stage and give.
Everybody on the dais and off the dais. In fact, I was supposed to talk on the women empowerment aspect of the topic, but unfortunately I was not aware of the fact that this session got changed. So I felt, let me express myself on the relationship between the judiciary, legislative and the executive. Well, the distinguished speaker still now has spoken about the theoretical part of it, as far as what is the separation of powers, Montesquieu theory, the Supreme Court judgment, so on and so forth. But I would like to take a different viewpoint. I would like to take the role of a common man of the country. After all, the rule of law is for implementation. For whose benefit? It is for the common man's benefit. And what is the common man's perspective of the rule of law? Or what is the common man sees this relationship between the judiciary, executive and the legislature? We have been talking about in the press that it is fanciful to blame the judiciary for the pendency of cases. More than 2 crore cases are pending here, there, so on and so forth. It's a matter of fact. But however, we generally miss on a point that the disposal rate of cases in India are extraordinarily high when compared to the disposal rate in other countries. Why is this situation? The methodology adopted in the disposal of cases makes all the difference. Where it is not time bound. I can argue a case for hours together or days together if the judge is ready to hear me. But is it the case elsewhere? No. And once I file a case, the case is being, it takes its own sweet time before it reaches its final hearing. So these are all contributing factors to the delay in judiciary. But now, is the judiciary to be blamed for this? Absolutely not. The reason is, I am talking about the relationship between the judiciary, executive and the legislation. In the common man's perspective, when there are 2.5 crore cases are pending in India, it is a statistical data that around 60 to 70% of the cases, the government is the respondent of the cases. Why not the government file its counter immediately within 6 months as stipulated in the rules of writ rules? It won't. It won't. Then who is contributing to the delay in the justice delivery system? Is it not the executive? By not discharging their responsibility within proper time schedule. Are they contributing to the common man's benefit? No. Is an affirmative answer which I would like to place before this August forum. Then, if supposing the judiciary intervenes and passes an order, why the government should wait, the executive should wait till a contempt is also moved in the same court? And in the contempt proceedings, if I am not committing a contempt, act of contempt, I may be permitted to say that why the judiciary is not taking a serious note and why the contempt cases are closed, because they are implemented. The act of contempt was committed when the order was not implemented. That is all about it. But unfortunately, once the executive comes before the judiciary and says we have implemented it, we close the contempt case. But are we not taking the teeth out of the Contempt of Court Act? Are we not supporting the delay process of the benefit to the common man? Because the constitution is given by the common man. Every citizen has given the constitution to ourselves. We have given constitution to ourselves. So it is my responsibility as a common man to question this. So this is one aspect of the pendency of the cases. And the next part of it is executive. At the drop of the hat, we have a new legislation. In my firm opinion that, though it is of 1872, the Indian Evidence Act is very well sufficient for today's requirement. The IPC is very well sufficient for various things. We don't require an act for throwing of acid, for throwing of ball, for throwing of a cricket bat, for throwing of something else. The existing laws are more than sufficient. Do we have a statistics of how many laws which are now in force in India? If any of either the executive or the judiciary or the legislative, I am afraid we may not get the data. If we try to get the information on the Right to Information Act, probably would not get the data immediately. When such is the status, can we expect that the common man is getting the benefit out of the separation of powers? I don't know whether I have taken a wrong stand, whether I am speaking the right thing or not from the present forum. But however, the relationship which we are talking about yes, the judiciary has to deliver the legal decisions based on the material before it, and it is bound by the legislature. And why the legislature is enacting n number of acts day in and day out at the drop of the hat? And is the legislature doing? Is there any system where the education qualification is prescribed to become a member, to go into the legislature? No. When that is not the case, again, it is the executive, the bureaucrats would create the document, and that is being spelled out in an open forum, whether the law is made by the legislature or by the executive. A question mark again, it needs to be answered. So, the identity of legislature, the identity of executive, the identity of judiciary should be known to the common man. The common man sitting across any part of the country should feel that, yes, the legislature is for my benefit, the executive is for my benefit, the judiciary is for my benefit. But is the common man feeling so? No. Unless this situation comes, unless something is done with a cooperative attitude. Now, we can notice a situation where, as the learned speakers were talking for a moment a little earlier, that the executive finds fault with the judiciary that they do not know this. And the judiciary finds fault with the executive said that they are not properly doing this. And the legislature finds fault with something else. Why is this fault-finding machinery taking place? Why not we act in coherence? Why not we act hand in hand and see that the common man gets the actual benefit for which they were made to sit in their respective positions? This is all a pointer I wanted to place before my friends. I did it. If I made a point, kindly continue the thought. If not, excuse me. Thank you.
To the speakers who were giving their thoughts, very thought-provoking matters. I especially mention about the last speaker. He repeatedly used the term common man. I think all the problems in this particular country lies with the use of that particular term common man. That has been hammered down in our brain. We never think that a man is not a common man. He is the master of this land. That thing we have always thought. All the legal luminaries are here. I should remind you that what the power has been given to that particular common man. Who is that common man? He is a citizen. You know what power the citizen enjoys? There is a judgment given by US Supreme Court that it is not our function, it is not the function of our government to keep the citizen from falling into error. It is the function of the citizen to keep the government from falling into error. This particular judgment has also been referred by the Supreme Court of India. Now, this shows where the citizen's power lies. In fact, in a democracy, power lies with the citizen, and no power lies neither with judiciary, nor with executive, nor with legislature. What they are enjoying is only responsibilities given to them by those common men actually who are citizens. We have forgotten about this. And why and how? There I am just giving you an example, and I am just sharing my thought. This is because everything lies with the problem of law in this country. And the supreme law of the land is the Constitution of India. That we know. But did you ever think whether this Constitution of India, which we call the supreme law of the land, it has a legal standing? I am questioning that legal standing in good faith. I am a citizen of India. I have full allegiance with the Constitution. That's why I am a citizen. Now I am thinking as a person from academic angle. Whether the Constitution, now I am thinking as a person from academic angle. Whether the Constitution of India, it has a legal standing as a supreme law of the land. Why I am saying? Let's go a little behind when India was under British rule. In the year 1947, we say that on 15th August 1947, India became an independent country.